So non-compete agreements are an agreement between an employee and an employer where the employee is agreeing that in the event that that employee is no longer going to be working for the employer, the company, their boss, or whatever you want to call them, that employee is agreeing that they're not going to go and work for a similar industry that is in direct competition with their boss, employer, or company. And some of these agreements even include a provision that will not allow this employee to take either clients, customers, or patients of their boss. Now in Florida, this is actually recognized as a valid contract so long as the time, the area, and the length and pretty much what they're trying to prevent from non-disclosure and non-compete is reasonable. So back in the day, this was not necessarily considered a valid contract because they didn't want to put any type of restraints on business, because this is America and businesses are supposed to flourish and they're supposed to thrive and there's supposed to be competitions. But then they realize that there are certain companies that are investing a lot of time in certain employees in either training, skill development, and all that sort of thing. And with that comes a lot of secrets, trade secrets, and formulas. I mean, Coca-Cola that was a very popular case where Coca-Cola had a non-disclosure compete and a non-compete agreement. So these type of things, they need to be looked at on a case-by-case basis. In fact, I believe it was in 2007, around that time, there was a Florida Supreme Court case that finally said, look, it has to be reasonable, just like what the statute says, but not only that, it also has to be the reasonableness has to also be looked at what it is that they're trying to prevent the employee from doing and what type of business it is. So if it's a type of business that has certain secrets like Coca-Cola, like their formula, then that may be considered reasonable over a company that has something that they're trying to prevent from being disclosed that's very generally known to the public. So again, you have to look for reasonableness, and please be aware that these contracts can be valid. And lastly, under Florida law, a legitimate business interest would be something that's considered a trade secret, valuable or confidential information from either a professional or a business. Then there's also relationships like patients and clients and that sort of thing, even marketing materials or trade secrets and all that sort of thing. If you have any questions though, please let us know. We are here to answer them, and we're here to continue our series of frequently asked questions, so we're kind of excited when we get your questions. So please send them over. Anna Fernandez of Legal Lotus. Have an awesome day.